Mr. Attorney General, the premise, evidently, for those who are questioning, trying people in these terrorist suspects that we're talking about in civilian Article III courts, the premise or the concern around the Miranda rights are that we won't get good information from them. So just a little bit of questioning, a line of questioning with regard to that. First of all, with regard to Abdul Muttalib, the Christmas bomber, a timeline. He was, and correct me to the extent that I'm in error here, I'd like to lead you through this just a little bit. He was taken into custody by security officials at the airport first, I believe, and then taken to the hospital, and then interviewed by the FBI team, which, as you described, was a pretty sophisticated group of
right.
people.
I believe that, I'm not sure, but I believe that's the correct timeline and the correct people who've interacted with him along the way.
Yeah. And so up to that point, Miranda rights are all preserved, because that's obviously, I think, an exemption to the necessity for issuing Miranda rights, public safety, questioning somebody in the heat of an arrest, and questioning, which is going to or in the aftermath of an event, because you do have public safety concerns. So you're more interested in that than you are in
yeah, and I also think you could argue that he was not. It was not at least in those initial times. You might even argue that he was not. It was not a custodial situation.
Okay.
So, but.
So he was questioned for some period of time without Miranda rights, correct?
Correct.
And then he was treated in the hospital, and then after he was released, he was Mirandized.
He was.
Is that correct?
He was Mirandized by a different team, a clean team, as we call it. And I think it was interesting that their view was that he came out of that procedure a different person, that he was more, I don't know, for lack of a better term, warrior-like. And I'm not sure that is, I'm not convinced, and this is just my personal opinion. This is Eric Holder's personal opinion. I don't think it was the Miranda warnings that made him decide not to talk. I think it was something within him that took him back to, where he was immediately before he ignited the bomb or whatever. He became that person again. So that's why I think he decided. He answered a few questions in that second interaction, but not many, and then ultimately decided he did not want to continue the conversation. But I think we should never forget that in the days that followed that, actually in the weeks that have followed that, he has been talking.
Yeah. Well, and then you're getting my point, but you're getting ahead of my point. My first point is that he was interviewed by a qualified team, and to undermine the qualifications of the team, I think, is I don't know what justification there would be for that. These are professional people out in the field who are trained in this very thing.
The people who did that first 1 hour, 50-minute interview, whatever, were good, trained FBI agents. And one thing I should clear for the record, to the extent that I said that the determination was made only by them with regard to the whole Miranda warnings question, that was not done only by them. It was also done in conjunction with people at FBI and Justice Department headquarters. I was not involved, but other people at higher levels within the department made those decisions.
Okay, so the suspect was interviewed prior to being Mirandized, was Mirandized, and was subsequently questioned after being Mirandized. Initially, it was difficult right after getting out of treatment, but subsequently, I think your testimony has been a number of times that a lot of good information or perfectly good information was gotten after being Mirandized.
And what people should understand is that there are studies in those briefs that we've heard about. I don't have it in front of me, that substantial numbers of people will, even after they are Mirandized, continue to talk, one, and two, once they are provided with lawyers, the lawyers can make a more objective determination of the fix that their clients are in, and the lawyers, the defense lawyers, frequently become not advocates for the government, advocates for their client, in the sense that they tell an Abdul Muttalib, unless you want to spend the rest of your life in a supermax facility, you better start sharing information with the government. And I don't want to get into the specific case, but that frequently happens, that the defense lawyer helping his client also helps the government.
And I think that's the point I really want to get to, is that if the premise of those who argue that a person should be questioned without Miranda rights is that better information is received prior to or by techniques which are employed without Miranda rights, that's a premise they'd have to prove, and it is certainly contested in the public debate. But in order to even get to the question of whether you should be Mirandized for the quality of the information purposes or not Mirandized would stand or fall on the basis of whether good information, better information be received by interrogation with people who are not Mirandized, and that's a premise that has not been established or laid before. So let's not presume in these questions, I guess is my point, that pre-Mirandized information or never Mirandizing somebody is better information than not. It's simply, as I understand it, not valid among an accepted premise among the profession. Your comment.
Well, I think you raise a very good point, and that is one that I would throw back at those who have criticized us for using the criminal justice system and the Miranda requirement to say, well, what is your proof that if he were whisked off to a military facility questioned by military people, even without the presence of a lawyer, that the information you would receive would have been more voluminous, would have been better? There are psychologists who we've consulted who say that, you know, the presence of military people in uniform makes them perhaps maybe warrior-like. I don't know. You know, there are, again, I would try to look at the facts and the experiences that we have had, and the use of the criminal justice system to get information from Abdul Muttalib, from Zazi, from Headley, from a whole variety of cases that we have had this year, I think shows the efficacy of that system and the efficacy of that approach.
Okay.